Today, there is no bigger news than what's happening in the Democratic Party. According to Democratic operatives, as well as some of the leading Democratic elected officials, there are alleged conversations taking place that have been going on since Thursday night about whether Joe Biden should step aside. Many folks are suggesting that Kamala Harris, uh, California Governor Gavin Newsom, Maryland Governor Wes Moore, and a host of others, including uh, Minority Leader Hakeem Jeffries, that all of these much younger elected officials, Democratic elected officials, that they should be the nominee at the top of the ticket and that they should win the endorsement of the 4,000 delegates that will convene in Chicago for the Democratic Convention in August. Well, for those folks who think that's an easy feat, that there's some magic wand that either that Joe Biden or some party boss can just, wave to make that a reality, I got news for you. It ain't that easy. There are lots of issues that have to be considered, both legal issues, financial issues, party issues, and the list goes on and on. So I'm super excited to be joined in hour two by a legal scholar because there are a lot of legal issues here. She is a professor at the University of Chicago's law school, one of the top 5 law schools in the country. She's a former member of the Presidential Commission on the Supreme Court. Her name is Professor Alison LaCroix. And also Andrew Heaton, a friend of mine, used to do a lot of shows with him a while back. He's a stand-up comic, but he's so much more. He does political satire, and he has brilliant insights on today's politics. He's the host also of the very popular political podcast called Political Orphanage. When we come forward, got to get Professor LaCroix and Andrew Heaton's take on all of this chatter. Some call it panic in the Democratic Party to replace Joe Biden. Is it just idle gossip that is likely to go away with the next big news cycle, or is there really something to this? And if it is, what are the logistics of replacing a candidate? Who is that replacement likely to be? And can the Democratic Party survive a replacement of the top candidate on its ticket? Welcome to the show, Professor, and welcome, Andrew. I got to start with you, Andrew. What are you hearing, and what do you think should happen in this moment?
I'm mostly hearing abject horror, and I think that there should be strong pressure on President Biden to step down. I think that you're right in terms of the difficulty of compelling him to do so. I think that the idea that there's just some sort of executive committee that you can snap your fingers on and everybody lights up their cigar and goes, well, let's just paradrop Gavin Newsom in. That doesn't exist. That's not there. So the only way this is going to happen is if Joe Biden is convinced to step down. And
well, let me ask you this, Andrew. Andrew, don't you think that's political suicide for the party? There is no consensus about who should be the quote unquote replacement for Joe Biden. We're headed into a convention literally next month, August 19th. Our Dem convention starts. I'm a delegate from California for the convention. So we would have total chaos at that convention trying to pick a leader of our party, trying to pick someone, not to mention all the issues with campaign finance laws, about all that money that's been raised for the Biden-Harris campaign. It doesn't just translate where you can just transfer that money over to whoever this new candidate is. They've got to pick a vice president. I mean, it's a complicated mess.
Very much so.
And if you pick someone, you know who Gavin Newsom is. I know who Gavin Newsom is. I'm from St. Louis, Missouri. I've asked some of my friends and families. They don't have a clue about him. So who has time to become a household name if you are parachuted in, as you said, into the top spot for the Dems?
So to clarify, I do not think this is good for the Democratic Party either way, nor do I think that there is a positive, everybody's happy path forward. What I think happened was it was a spectacularly bad debate on account of Biden. Biden didn't look good. There was already a lot of framework going into it as a kind of referendum on his virility and fitness as president. And within that framework, I think he did very poorly. And the downriver effects of that are twofold. One, it's a lot harder for the Democrats to now make the argument that Donald Trump is an existential threat when the front runner they put up is an 82-year-old man whose abilities are in doubt. It would seem to lower the actual threat level by doing so. And then the other bit is just there, I think, are a fair amount of people that are independent or in the middle who are going to be swayed by that. And I'm worried that this is going to be a hobble that Biden can't get over. That the footage of him stumbling is going to be used again and again and again. And so from where I'm at, I think it's better for the Democrats to recover by having a crazy, chaotic brokered convention and moving forward from there.
Yeah, I just disagree with you, Andrew. Look, we had to get over voters for the Republicans got over Donald Trump calling, making statements about grabbing women by the pee. They got over the fact that he has 91 criminal counts, felony convictions filed against him, 34. He's actually been found guilty in a Manhattan court. So, I mean, the list goes on and on of things that the Republican Party has decided is okay to support this man at the top of their ticket. But yet somehow now the Democrats, because Joe Biden stumbled in one debate that has an administration, second in command, Kamala Harris, the most competent, I would argue, administration yet in this country, or at least one of the top administrations, that somehow we've got to kick Joe Biden to the curb for his fumble, but yet we can stand with a man that, according to his own former communications director, lied every 100 seconds on that debate stage. So we just kind of normalized the fact that the man who would be the president of the free world literally couldn't get clearance to be in the White House as a convicted felon. He couldn't get a job at a bank. He couldn't get, half the jobs in this country with his felony record. I think we finally have gotten Professor LaCroix. She was having a little technical difficulties. Let me get you into this conversation, Professor. Thank you for joining us. This whole notion that we can just trade out, have a brokered convention, what do you say about that? How complicated is it? And what would that outcome likely be if the 4,000 delegates, I'm one of them, decided not to vote for Joe Biden as the candidate?
Well, it would certainly be very complicated, the likes of which we haven't seen in modern American politics in quite a while. Although I will note, sitting here in Chicago, I think when you talk about the Democratic Convention in Chicago, people think 1968, but there was 1860, and that was the one that ended with the nomination of the Republican Convention of Abraham Lincoln, and that was a surprise. They went through a number of ballots, so different Republican Party, obviously then, but it's not unprecedented. We tend to have a very short historical memory in the United States, especially in politics and law, but that's not that long ago. But yes, I think realistically today, that would be extraordinarily complicated. But then again, we've seen surprising things happen.
Let's talk about campaign finance laws. I've read something that suggested that Biden and Harris could not just simply transfer the billions of dollars that they've raised, fundraised for their campaign over to some new candidate, that it's not that simple. Is that accurate? I don't know if that was an accurate statement. You got to be so careful. Everything you read in the news today, most of it is not true and accurate. So I'm asking you as someone who hopefully knows the answer to that.
Well, my sense is, it depends, very lawyerly answer. But what I mean by that is I suspect that if a donor had given money to, say, a campaign or to the Democratic Party or to some other entity that is not specific to the person and the individual candidates, that seems like it could roll over. I'll caveat that with election law is not, campaign finance law is not my specialty. And also, if you still have Vice President Harris on the ticket, certainly that's an individual person who would be a recipient of those funds, perhaps in either case. So I don't think that those funds are generally given to a personal person, but it would, of course, depend on the terms of the donation.
Yeah, I don't know the answer, Robert. You may be able to find some legal scholar that's opined on that, but I remember reading very distinctly that there would be some huge issues with the transfer of the funds, again, that would cripple any candidate, obviously not in a position to raise the kind of money you would need to run for president in the short period of time that would be left. We'll come back to that. We have to figure out what the accurate response to that is. Andrew, this Supreme Court today ruled that Donald Trump has some broad immunities. One of the concerns about Donald Trump winning the election is this notion that the two oldest and most conservative justices, Samuel Alito and Clarence Thomas, would be given their walking papers, would be asked to retire, go off, make millions of dollars on the speaking circuit, and that there would be the appointment of two young and even more ultra-conservative justices that would push this court even further to the right. Do you have any concerns about that?
I am one of the few people in the country that likes the Supreme Court in general, and I say that in the sense that I have a low opinion of a number of members of Congress, but I think everybody on the court, whether I like them or disagree with them, is very intelligent. And I think that the extreme nature of the court is overstated. You have a law degree, so I defer to you on this, Areva, but it seems to me that the conflict that constantly plays out in the court is the balance between the originalists on the one hand and the living constitutionalists on the other, which is an interpretive model of jurisprudence rather than just pushing Republican policy or pushing Democratic policy. And the evidence that I would submit to that is that recently the court was overviewing milafistrone. I'm making it sound Italian here, but the abortifacient drug that was up for it. And I believe Kavanaugh was the one that wrote the majority opinion that said, no, this is legal. So I don't think that the conservative court is just picking a conservative goal and working its way there. And I think that the court session this time around had a
wait a minute, Andrew.
Yeah.
Andrew, let me stop you there. Donald Trump says to the contrary. He said he purposely handpicked these justices so that they could overturn Roe v. Wade and usher in a new conservative era on the court. Those were his words, not mine. And I want to get Professor LaCroix in here because she is a former member of the Presidential Commission on the Supreme Court and an expert on the Supreme Court, maybe not campaign finance law, but what do you make of Andrew's statement, Professor, that somehow the courts, that we overplay this conservative versus liberal bent on the court?
Well, I think there's a bunch of different ways one could think about what conservative is. And I think we tend to think in politics, we tend to think of it as partisan and Republican versus Democrat, for instance. But on the court, I think it's more complicated. And so, as Andrew said, we have the originalists, sometimes the textualists. Those are distinct. One is kind of, do we look at what the founders either themselves meant or what it would have meant to their audience? Textualist, we can read the text and we understand what 18th century people meant when they wrote because we can recognize it. And then others who do other things, who are sometimes grouped under living constitutionalism. Now, it's often the case that originalism and textualism skew conservative in how they're applied. But I'll also note that sort of even if one takes, like, for instance, the Trump sort of judicial appointment strategy at face value, the conservative Supreme Court, the sort of marching papers that President Trump gave to his staff when he was in office, even if we say they're trying to do conservatism and originalism as a piece of that, one thing I would note is that in a lot of these big cases we're seeing right now, they're very selective in when and how they do their originalism. So even for many of them, their sort of standard method is applied pretty haphazardly, which is interesting because often the conservative claim about originalism is that it helps constrain judges. But I think we see, I mean, the immunity case today is a great example. There's sort of a few examples that, in quotes, picked out of the Federalist essays from 1788, 89, but basically ignoring the sort of historical practice in the early American Republic, which was not always and not often because it didn't come up that much, but to treat the president as not above the law. And so there's a selectiveness about how they use history that is also, I think, something we should hold them to account for.
Yeah, and some would argue, Professor, that selective amnesia, let's call it that, is a way of promoting, supporting, advancing some of the conservative ideologies. Again, it was Donald Trump who touted appointing a conservative justice to do what he said the conservatives have wanted them to do forever with respect to the overturning of Roe v. Wade. Andrew, we don't have a crystal ball. Nobody knows what's going to happen at the convention. We did get an answer, I think, to the question about the money, though. There was a statement made by the Biden campaign manager, Julie Chavez, that whatever happens with Joe Biden, you are right, Professor, Kamala Harris controls $91.2 million. as of May 31st. So if they want to get rid of Biden and they want that 91 million, it looks like Kamala Harris better be in the mix. And I doubt if Kamala Harris would be in the mix to be somebody else's vice president. So all these folks that want to replace Biden, they better ask themselves, are they really going to get behind an African-American woman to be the president? When she ran for president, we know she wasn't successful, Andrew, in their primary, and we know her ratings have been really, really low over the last couple of years, although she enjoys tremendous support in the African-American community and other communities. But what do you think of that? Kamala Harris got the bag.
I think that makes more sense. So I'm going to quit pretending to be a lawyer for a moment. I'm going to go into my default mode as a comedian with you, where I think I have better insight here. It seems to me right now, the choice that America has between Trump and Biden is an old guy who is getting lost and driving his car through the mall, and an old guy who's driving his car through the mall for fun on purpose. So neither of these are great outcomes for me. And while I'd probably go with a guy getting lost and accidentally driving his car through the farmer's market instead of swerving to hit squirrels, I'd probably do that. I would feel a lot more comfortable with somebody that is just not driving through the mall at all, including Kamala Harris.
I'm glad to hear that. And again, like I said, I've been talking about this over the last couple of days with folks and polling people on this whole question of Kamala Harris, because like I said, if there were a poll to be done before that debate about whether you wanted Kamala Harris to be president, I don't think she would have fared very well. But now, obviously, with the driving or dragging the car through the farmer's market analogy, maybe Kamala Harris is looking a whole lot better, Andrew, to folks now. And particularly if she got $91 million in the bag that comes with her, she's probably looking damn good to folks. Andrew, predictions. What happens in this debate? If you had a crystal ball, what do you predict happens?
Following this debate, in terms of just going forward?
Going into the convention, going into Chicago, is it a brokered convention? Or are delegates going to just vote the party line and Biden's going to be the candidate?
I think it's going to be a brokered convention. I think that it was dismal enough last week that there are conversations happening right now. When I watched media coverage, I was live streaming it. When I watched media coverage, the people that were very much in the Biden camp did not look to me like they were shrugging it off. And I think that people that are in the party position of actually running the party can't come out and say this was a disaster, but I think it was. And I think there's a lot of pressure on him. I mean, I would say smart play right now would be for Biden to potentially resign, if only to give Kamala Harris the incumbent advantage where she goes in as the president. So I think a lot of weird things are going to happen over the next few months, and a brokered convention is the most likely outcome.
Thank you so much. Again, this is Andrew Heaton. He's a stand-up comic. He does political satire. He's host of the Political Orphanage podcast. You can find that every place podcasts are found. Thank you so much, Andrew, for your insights today. When we come forward, Professor LaCroix is going to stay with me because we're going to talk about some of these blockbuster cases that have been issued by the Supreme Court just in the last week. A lot of surprising decisions by this court. When I think about the debate on Thursday and this talk amongst Democrats about replacing Joe Biden, the biggest issue I'm focused on, one of the big issues I'm focused on, is the Supreme Court. And Hillary Clinton's loss in 2016, which is how we ended up with this very conservative 6-3 court, and the fear that if the Democrats lose in 2024, that court can even become a 7-2 majority, conservative majority, and even have justices that are more conservative than Alito and Clarence Thomas. There's talk that the two of them will retire to go make millions of dollars on the speaking circuit, and that even judges like Eileen Cannon in Florida, the judge overseeing the classified documents case, who seems to be doing Trump's bidding, might be on the short list to go to our U.S. Supreme Court. And the court has lost a tremendous amount of trust amongst American people. Polling after polling shows that people are losing trust because of the justices, their entanglements with millionaires, billionaires, their accepting of gifts, and just all of those things that once before were thought to be totally off limits for our U.S. Supreme Court. Professor LaCroix, obviously today, that big decision about Trump immunity, a clear victory for Donald Trump. the justices ruling that he's absolutely immune from prosecution for any conduct, quote, involving his discussions with Justice Department officials, quote. We know this is a significant segment of his federal indictment. This seemingly would take off the table Trump's interactions with Justice Department official Jeffrey Clark, who was a key figure who has been indicted in Georgia alongside with Trump, as well as other top Justice Department officials who told Trump that his voter fraud theories were categorically wrong. What do you make of this decision today and what appears again to be this 6-3 court going out of its way to give favor to Donald Trump?
Well, one thing that really surprised me about the decision was the kind of how the court got to it, because I wasn't surprised that they said there's some category of things for which the president has absolute immunity. That seems, in theory, that makes sense. And I wasn't surprised that they didn't say there's no absolute immunity. And then there was this sort of question about, well, what about in between? How are they going to draw that line? And yeah, obviously we saw or we heard at the oral arguments that this official acts, unofficial acts line mattered a lot. Some of that coming out of prior case law to say most of the time, this was the prior case law, most of the time the president isn't immune. But there's one Supreme Court case involving President Richard Nixon where the court said, okay, he's immune from this because it was an individual who'd been fired from a government position trying to bring a money damages suit. And that's very different from a criminal prosecution. So I thought, or I think the law suggested that they had that one case that said immunity, but that was only for someone basically trying to sue the president for something very much in his official kind of day-to-day work as president and trying to get money damages. In the other cases, again, prior to today, especially the ones about President Nixon, the court always took very seriously the fact that it might be dealing with a criminal case sort of in the parallel track with what it was trying to get from the president. So US versus Nixon in 1974, the court said, we really care a lot about the fact that we're trying to get these tapes and materials from Richard Nixon, all the Watergate stuff that we now know. And that was because other people, Nixon advisees and advisors, were being prosecuted. And there in the 1970s, the court was saying things like there's a public interest in the even-handed application of the criminal law. And we didn't really see any of that in today's decision. It was much more about what the majority kept referring to as the danger of intrusion into the executive branch's authority. Obviously, that's significant. Again, we want our presidents to be able to get candid advice and talk to people and sort of, not be kind of on the record for everything. But it was surprising to me that the court didn't spend any time on this kind of public interest in fair and effective law enforcement. They mentioned it once and then they just kind of breezed past it. And in doing that too, they came up with this new category of what they called presumptive immunity, covering a lot of these official acts. And that to me is a concern because it says to not just President Biden now or former President Trump, but potentially all future presidents, just assume you have immunity for anything that looks official. And as you were saying, anytime they're talking to a Justice Department official or the vice president, no matter what it's about. And that's a very, I think, dangerous precedent, just in terms of we the people controlling what the president is up to.
Yeah, Justice Sonia Sotomayor wrote a dissent, and she said the courts has shifted the relationship between the president and the people he serves. Said that relationship has shifted irrevocably in every use of official power. The president is now a king above the law. And she went on to talk about these examples, these hypotheticals. He can order the Navy SEAL team to assassinate a political rival. She says, question mark, immune. Organizes a military coup to hold on to power, question mark, immune. Takes a bribe in exchange for a pardon, question mark, immune, 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 immune. Do you think Sotomayor is, being is she using hyperbole? Is she exaggerating? Or is this relationship shifted in such a dramatic way that the president now is basically a king above the law?
Well, a lot of it depends on sort of how we read the opinion and what we think might be the difference between the law and the opinion and how people will respond to it. So first, I mean, one could take some solace or some hope from the fact that the opinion says, okay, absolute immunity for these core constitutional powers, then presumptive immunity, but we'll have to have a trial about it, because that's kind of where they ended up with a lot of the issues in the indictment here. Well, we need a lower court to kind of go through, do fact finding, get witnesses, do a bunch of evidence gathering that we don't have. Now, could you have a district court, a lower court, do that in some of those scenarios that Justice Sotomayor raised and then say, okay, no immunity? Yes. And, that's a hopeful sign if you care about the president being subjected to the law. But kind of moving outside the frame of how we might think of the cases operating, the signal here, I mean, it's more than a signal. It's basically a statement to the president and to all presidents coming down the line of, kind of act first, ask questions later, but maybe never. And that's something new. I mean, that was not the law, before this opinion came down. I think it wasn't clear whether presidents were immune from criminal prosecution for most things. And now it's clear that they are immune from criminal prosecution for most things. And again, especially when they're talking to executive branch officials. Justice Barrett in her concurrence said, well, what about the Arizona Speaker of the House, like a state official? And she says, I agree with you majority for most things, but, look, this is someone who's outside the executive branch. We surely can't think this absolute immunity extends that far. So there are some kind of carve outs, but, there's also, again, this signal of act first, deal with the fallout later.
Well, what's your opinion about how long it took this court to get to this decision, and now sending it back down to Judge Chuckin for her to have this factual determination about what's an official act and what's not, what he can be indicted for, what he can't be indicted for, knowing that this will delay the trial, presumably past the election date, and whatever Judge Chuckin decides about what he can be indicted for, he's going to appeal it back up to the Supreme Court again yet anyhow.
Well, yeah, I mean, I think the delay, even when the Supreme Court granted the appeal, people said the delay goes straight to Trump's advantage. And that's clear. That's still true.
But what happens, though, when it goes back to Chuckin?
Well, I mean, the district court, the trial court, will sort of decide, right? They should say, well, listen, we need to actually work through the charges in the indictment and say, okay, what's the evidence about this? So, for instance, if it's this instruction to the Arizona House Speaker, allegedly, let's do fact finding. Let's try to figure out what actually was discussed. Do we feel like the prosecutor has overcome the presumption of immunity? And if so, then the president's not immune. So you can imagine a bunch of almost individual mini trials about every count in the indictment, because they all involve very different fact patterns. And then the ones about Vice President Pence or the acting attorney general, those will just be off the table because absolute immunity applies there.
But doesn't that set these mini trials, the decisions which Donald Trump will never accept, to end up back before the Supreme Court, yet the Supreme Court having to determine again if the district court got it right? I mean, we can see this being batted around like a tennis ball for the next, 2-3 years, because Donald Trump is never going to accept that he should be indicted for any of his conduct. I want to ask you about that, and also about the court's decision on Friday about the insurrectionists. How do these two decisions just embolden Donald Trump? We've already seen reports today that he is now challenging the convictions in that Manhattan Supreme Court, feeling as if the Supreme Court is likely to determine that he could not be prosecuted for those actions, and overturning that conviction even in that Manhattan state court. So we got that decision about immunity today. Big victory for Donald Trump. Gives a broad immunity in criminal cases that heretofore did not exist. The Supreme Court siding with Trump and his lawyers on many of the key points in that case. Obviously, the case has been sent back to Judge Chuckin, the district court judge, but we should expect her to narrow substantially the indictment by Special Counsel Jack Smith. But there was also, Professor, a big decision about the insurrectionists and the federal obstruction statute on Friday that, again, seemingly favored those individuals who stormed and broke into our Capitol, those that have been charged under a particular obstruction statute, many believing that that decision by the Supreme Court will also inure to the benefit of Donald Trump. Talk about the court's decision in that case and what impact, if any, you see it having on his prosecution to subvert the 2020 election, both the federal case and that state pending case in Georgia.
Right. Well, this was the decision in Fisher versus U.S. And this was not a case that directly involved former President Trump, but it was about the January 6th insurrection. And the court threw out the charges against a former Pennsylvania police officer who entered the Capitol, and that was not disputed. What was disputed was the law that Fisher was charged with violating. This was a federal statute that came out of the Enron kind of financial scandals, part of the Sarbanes-Oxley Act. Seems like that's about a different context, but the argument the prosecutors made was, look at the face of the statute. It's a crime under the statute to obstruct, influence, or impede any official proceeding. So the argument was what was going on in the Capitol on January 6th, the legal events that were going on there were official proceedings, and this was an impeding of them. Court said, well, that's only about evidence tampering. It's about documents. It's about people covering up financial wrongdoing. This is a potentially extremely consequential decision. I think we're already seeing this because we've got a couple of hundred of other January 6th defendants, and indeed former President Trump being charged by the special counsel under this same statute. And so, yeah, I mean, the statute at issue in that other case, Fisher, so if that only applies to people who are doing evidence tampering, then theoretically, or one would assume it doesn't apply to former President Trump. And then also, if you sort of overlay the immunity opinion over that case and you say, well, let's say a court or the special counsel is trying to bring a charge against former President Trump for other congressional statute violations, other unlawful acts. For those things, he can now, after today's decision, potentially get some shielding through the immunity. Although that's where we then get back to, well, okay, maybe when he's talking to Vice President Pence, that's absolute immunity. When he's talking to the United States Acting Attorney General, immunity. What about these other persons? And the court, the majority opinion today, didn't really give us any examples of what would not be covered by immunity. But reading by kind of implication, there have to be some. And this, again, is this point that Justice Barrett raised about state officials. So are state officials necessarily covered by this executive branch immunity? Seems like not. But now this really resets a whole bunch of things that would have to be proved against the former president. And again, then you don't just have to prove the kind of underlying elements of the crime, but now you have to fight off, if you're the special counsel or another prosecutor, you have to now fight off the immunity claim. So you've got another layer to battle through.
You know, I'm thinking about attorney-client privilege. And you know, the significance of the attorney-client privilege in our legal system, but the way in which that privilege is pierced when you are, you know, planning a crime, you know, you're involved in criminal activity, the lawyer, the client. And so I'm just wondering if Donald Trump is talking about criminal activity, in talking to his attorney general or his attorney or the vice president, that doesn't matter to this court, right? He could be plotting literally to invade illegally some other country or to kill some political opponent, and he still would be shielded under this decision.
That is how the majority opinion frames it. Yeah, because they make it so much about who the other person is. And I think, as you said, the attorney-client privilege analogy is a really interesting one for that reason, because, I mean, they say things like, this is Chief Justice Roberts, it doesn't matter if the president is engaging in acts that are otherwise unlawful. It doesn't matter what the president's motive is. It's about sort of who's in the room with him or her when that conversation happens. And then one might, you can imagine different scenarios that spin off from that. One is, they're really talking to a private party about how they're going to commit extortion or sort of engage in unlawful acts. They bring in some Justice Department lawyer to kind of make a protective shield around the whole conversation. Is that how it would work? Or would it work more like attorney-client privilege, where the regular private party in there disrupts the shield that the executive branch official brings? If we read the opinion from the Chief Justice, it seems like it's more of a kind of magic touch from the executive branch official, because they talk so much about not wanting courts to intrude in these kind of discussions and deliberations, all of which are in the executive branch. And again, they're so worried about the intrusion into its function.
Yeah, that's very, very troubling. You're right. So I want to plan a murder plot, and as long as I bring in someone else from the executive branch to just sit in the room, even though they may not be vital to the conversation, what prevents you from saying no? There's complete immunity because the conversation took place. The other person involved, maybe the person nods their head, says yes, that's right, that's wrong, but somehow now just their presence alone would give that kind of immunity. What concerns do you have, Professor, about Trump, not just any Republican, but Donald Trump in particular, having an opportunity to appoint additional justices to the Supreme Court, given the ages of some of our sitting justices?
Well, I mean, one thing it makes me think, and I thought this when he was president previously, was, when you hear people say, well, it doesn't matter who I vote for, they're kind of all the same. I mean, there are clearly a lot of similarities here between the two presumptive candidates. But then you look at appointments to the Supreme Court and to the lower federal courts, I would add. And boy, it really matters, So I feel like we're in this moment where the Supreme Court is enormously powerful. I mean, they sometimes talk this talk of judicial modesty. We want democracy. We don't want to decide. But let's make no mistake. I mean, they are supreme. They are really powerful. And so that's a reason to vote, because, yeah, it's kind of the president, might or might not get to appoint Supreme Court justices. But when they do, as we saw with President Trump, that has a significant effect that can long outlast the president, let alone possibly protecting or shielding the president from committing unlawful acts. So it's really, if one couldn't find other reasons to vote for president, that's, I think, the key one.
Yeah, two big decisions. Friday and Monday are two big decisions to vote. I want to thank you, Professor LaCroix. I want to also let people know you are the author of a book called The Interbellum Constitution, Union, Commerce, and Slavery in the Age of Federalisms. This is a compilation of legal, political, and social history written to show how the post-founding generations were forced to rethink and substantially revise the U.S. Constitution. This is one of many books that you've written on these topics. We really appreciate your insights and your contribution to this discussion that's taking place, so critical a discussion. Thank you so much for joining me. Lots to talk about. We are not going to resolve all these issues about what's going to happen with the Democratic Party, the candidate, but we do know that voting does matter. And as the professor said, if for no other reason, who gets appointed to our federal courts is decided by who sits in that White House.